Okay, we're going to make a start because we want to ensure that we have a little bit of time at the end to have some interaction from yourselves, some questions and comments on the discussion that we're going to have. So, as you know, my name is Esther Stanford-Xosei, and we are now going to have the Law and Reparative Justice panel discussion. We're looking at legal pathways to repairing injustice. So in this panel, we will discuss legal structures that permitted the transatlantic trafficking of enslaved African people and the legal frameworks to achieve reparative justice. But also we have to be mindful of how the law itself has been used as a weapon of conquest, as a weapon and tool of oppression, as well as a tool of resistance. And hopefully we will be able to tease some of that out in the various presentations that we have. So I'm reminded here, just in some introductory comments, of some comments from Brother Kofi Mawuli-Klue that was presented to the first reparations conference that took place in Birmingham in 1993. And in his paper, Charting an African Self-Determined Path of Legal Struggle for Reparations, he said, "The use of law is one of the most important instruments of our African struggle for reparations. Indeed, the need to locate our claim to restitution for the damages caused by gross violations of African sovereignty, enslavement and colonization, and neo-colonization within a framework of law and justice must raise immediately for us the essential questions of whose framework, whose law, and whose justice." And with that said, I would like to first welcome to speak to us Peter Herbert, OBE. And many of us know Peter, but Peter is one of the UK's best-known lawyers. He's a successful barrister and also operates as a part-time judge. Peter is a founder and chair of the Society of Black Lawyers based here in the UK. Thank you, Peter.
Thank you, Esther. Can I just correct a couple of things? I didn't found the Society of Black Lawyers. It was founded by Rudy Narayan and Sigbert Kadri in 1973, and it is the oldest African, Caribbean, and Asian lawyers group. One little request. Can somebody please, because I've got requests from people doing funding applications out in Kenya and various other places, can somebody take some photographs that I know and take a couple of videos, less than 60 seconds, so I can post them all over the damn place when I've finished. I think it's 6 minutes or 5 minutes?
Five to six.
5 to 6,
Yeah.
so I'll take 6, right, all right. So let me say thank you to Esther, to Jacqueline, to Belle for organizing a marvelous event. You got me here from Nairobi in some nice weather, playing golf and having a good time planning a conference, so you must have done something. Also, there are two amazing Kenyans here, Kimutai Bosek, who's one of the leading human rights lawyers, who is in the audience this morning, and also Sister Yvonne, who's a parliamentary representative who's Kenyan Swiss. So you can see just about the importance of having conferences like this take place. So my background very, very quickly is that my father was from Sierra Leone, my mother was English. The ancestry of my family can be traced back to Georgia. They escaped the Civil War and went to Nova Scotia. From Nova Scotia, they came to London in 1873 and back to Freetown again, and then back to London in 1945 on a troop ship. So to say that we are part of that enslaved people's story, and I didn't know some of this background before I went to the US as a guest of Angela Davis and people like that with the Society of Black Lawyers in 1988. And so I rediscovered some of my roots and from some of the civil rights activists there, and involvement with the Society of Black Lawyers has brought me round full circle. So any of you who are thinking of even dreaming of going to Kenya, make sure you get there for the Bandung conference, and those of you who don't know your history, you should know what Bandung means, but it's the first Pan-African Congress in 1955 for the liberation movements of African and Asian people in Indonesia. Malcolm X was there, and he met Phyia Pinto, who's the father of the Mau Mau movement in Kenya. They became good friends, and at the height of the insurgency in Kenya, Malcolm X visited Kenya for 2 weeks. So there's some history that we all have to get. I actually want to take a slight right turn on looking at reparations for enslavement and take you into a place which is partly inhabited by lawyers, but partly inhabited by activists. If you go to northeastern, western Kenya, you will find anybody who has a cup of tea, you're likely to find that at least the best part of the tea comes from Kenya. What they don't tell you is that British settlers before 1920 took some of the best farmland in Kenya, and they still got it. 200,000 acres in Kericho and Bomet County, held by Unilever, which doesn't pay tax in Kenya, doesn't pay tax in Britain, and it basically is part of the post-colonial struggle, which has impoverished Africa. And if you go there, you'll see one side of the road, which is tea plantations as far as the eye can see. On the other side, you generally see the results of impoverishment of smallholding farmers. Del Monte, the same. Kukuzi, the same. And so all over the continent, you will see the remnants of, the very deep remnants of colonial legacies, not just in Mali or Ivory Coast or Togo or South Africa or Namibia, all over the continent. Duchy of Lancaster, I think the royal family still owns chunks of Kenya and chunks of Tanzania. So the next time you go and look at an elephant in a wildlife reserve, which is supposedly conservation, look who owns the land, and look who should have owned the land. So some of the interviews I've done in Kenya have been with people who are the descendants of Mau Mau veterans, the descendants of Maasai and indigenous peoples who've had their land taken and they're squatters in their own land. So when we're looking at reparations, there is a historical precedent. The American government gave the Japanese Americans compensation for being detained in California during the years after Pearl Harbor. Precedent. In Namibia, the German government awarded the Herero and Gama people who were assassinated in the first genocide, first of the modern genocides of European powers, post-colonial. And those reparations figures, I think, are 4.3 billion euros. Whether it ever gets there is another matter. But those indigenous people still face persecution in both Namibia to some extent and in Botswana. And the problem is, and I see this firsthand in Kenya, the enslavement of the mind continues. Where do the leaders of most African countries go? They go to international schools taught by British teachers straight out of Harrow and Yorkshire. And is it surprising then that many of the African and Caribbean leaders still have ignorance in their head because they're given a narrative which is the narrative of the hunter, not the hunted? And so one of the things we have to do is decolonize the mind, because in a sense, even if you get huge amounts of reparations, where's it going to go? It's going to go in some chateau on the banks of Geneva, and it's going to go to send some privileged children to even more privileged schools to learn more about the way in which they are privileged, and the rest of the communities, whether it's in French-speaking, Anglophone Africa, doesn't know their own history. And so one of the things I think we have to guard against in this is to make sure that the biggest job we have to do is probably the education of our own. Mm-hmm. Because unless you educate your own, and you can see it every day of the week with lottery winners. I mean, really, do we want to become a lot of lottery winners that then are poor again tomorrow? Because that's exactly what will happen. Mm-hmm. You have to have a certain amount of knowledge to empower yourself for that future. But I'm an optimist. I'm near the end of my time, but I can say that if you put the legal knowledge together and on the continent, and you do one thing, which is activities, because leaving with this thought, when we had demonstrations with Bell led in London outside Unilever headquarters in 2020, in July, at the height of COVID, we held a demonstration in Unilever headquarters in Kericho County. What can happen is, though, you can push the law. You occupy the land. Who the hell needs to go and file a motion first? Occupy the land, pick the damn tea, take what is yours, And then when they come to arrest you, and you will get arrested, well, that's fine. You then challenge that because you cannot steal what is yours.
Yes, very powerful ending. You cannot steal what is yours. Thank you, Peter, Herbert, for that opening contribution. We're now going to move swiftly on to hear from Professor Kwame Akuffo, IOBE, and he is an Emeritus Professor of International and Comparative Law at the University of West London. Thank you, Professor.
Chair, with your permission, I'll remain seated if I could, because I had a stroke 3 years ago, and I've left a bit paralyzed, or rather paralyzed and also blind. So I shall make my contribution from it. Thank you very much indeed. Okay. Thank you all very much for being here and for the opportunity for us to make these contributions. But before I make my preliminary observations, I'm reminded of a statement made by a well-known legal historian called Maitland and his colleague, that such is the unity of all of history that anyone who tries to tell a bit of it must feel that his very first words tear a seamless web. Now, this web connects all of us in the most intimate way. And if I may start with a personal story, one of my favorite calypsonians is David Rudder, and in one of David Rudder's songs, he talks about and Europe making us basa-basa. Now, if you don't know what the word basa-basa means, alliterative nature alone tells you that it's not something that's good. Basa-basa is just you're messed up, bad. So that's what Europe has done to us. And my personal story, which I only discovered recently, is this, that my great-grandmother, the mother of my father's mother, was an enslaved woman from Antigua, who left Antigua to travel back to Africa with her brother in the 1850s and so on. Now, I always knew that I loved Calypso, but I didn't know that it was also in the blood. Actually, it was, literally. So it's all very complicated, and we're all connected to this global history, at the center of which are these dominant powers, and we, unfortunately, for centuries have been the objects, not the subjects, the objects. Now, before I make my substantive contribution, can I just start by saying that if we're here to look at the relationship between law and reparative justice, but can I warn that law is such a limited instrument, it is a potential potent instrument, but at the same time, it has severe limitations because of its nature. It would be helpful if that is the instrumentality that we're going to rely on. We must be aware of some of these limitations. I mean, we heard some from the conversation with Jackie this morning. But for example, there are arguments over whether or not time has run us out, whether or not limitation statutes and so on apply in relation to side claims that may come under reparative justice. Also, there are issues over who have the legal capacity to bring these claims, who are the defendants, and who pays at the end the bill and all these things. So I think it is important from the outset to understand that law lives in society and therefore is best understood in the more complex context of the wider politics, economics, psychology, sociology of, if you like, life generally. It's only when you view law in that broader context that law makes sense. So in our conversation around reparative justice, it's important to locate the conversation within these broader realities and so on. And my second broad observation relates to human rights. I think it's clear that the conversation around reparative justice has got to be based on the law that today we recognize as human rights law for a number of good reasons. Firstly, that human rights law represents the highest juridical form, the highest form of law in our contemporary world. I'm reminded of a book written by Costas Douzinas, in which he acknowledges that a new ideology has triumphed on the world stage, the ideology we call human rights. But it is contradicted by the fact that at the same time that it has triumphed, we're also witnessing some of the worst abuses of human rights that we've known in our history. And generally, people accept that the enslavement of our peoples constituted the worst kind of human rights abuse that there is. Now, the reason why, for me, human rights is such a potent legal framework to use for any analysis of slavery and enslavement and so on is the fact that it's based on the idea of natural justice. Natural justice in the sense that human rights come from a place where, and you may be reminded of the historic constitutions, including the American Declaration of Independence. It said, we hold these truths to be self-evident, that all human beings are created equal and that they're endowed by their Creator with certain inalienable rights. And included in these rights are the right to life, liberty, and the pursuit of happiness. Now, the right to life, liberty, and the pursuit of happiness. Now, if you accept that these are inalienable rights, it means that human rights come from a place where you have your rights not given to you by the state. There are rights that inhere in you simply by virtue of your nature as a human being. Now, within the context of human rights, therefore, any violation in the form of reducing a human being to a commodity and then assaulting them and selling them and making them work for nothing constitutes a basic violation of this inalienable right that we have to freedom, to liberty, and the pursuit of happiness. And also the United Nations always frame the reparative justice conversation within the framework of human rights. It also has the advantage of getting over some of the petty legal issues such as time limits and whether or not we are out of time, because human rights wouldn't have any, because it leans towards equity. There is no time limit in statutory terms, so we can pursue our claims on the basis of what we call in this country jurisprudence equity. The only time limit in equity is that delay defeats equity, and that depends on all the circumstances. So we can use it as a powerful tool to counter any of the bourgeois legal arguments that are often placed in the way of the reparative justice argument. But in substance, in terms of the legal strategies, I'm very fortunate to have recently come back from Ghana, my ancestral home. And the thing that struck me most was the sheer poverty and hopelessness of many of the people who live in that country. And there's absolutely no reason for it. Ghana is a very, very rich country. Apart from South Africa, Ghana is the biggest exporter of gold, the whole of the continent. Indeed, as you know, it used to be called the Gold Coast, and not for nothing, that eponymous name. It also has manganese, bauxite, you name it. But unfortunately, I had the misfortune of witnessing a group of fishermen around Tema coming back from fishing or trying to fish. They went to sea at 2 o'clock in the morning in the canoes. You know, the Atlantic is a very violent sea. And when they came back, they had no fish at all, nothing, I mean nothing. They had carrier bag, plastic bag, which they fished from the sea, and nothing. And they were complaining, how do we feed our families? How do we feed ourselves? Because the government apparently has cut a deal with some Chinese firm or some Chinese to fish the whole of the Gulf of Guinea, all the way to Senegal. So people have what should be our natural resources, the things that is ours by right, by any means, whether international law or by custom, whatever it is. People can no longer eat. So the questions that we're facing here are existential, they're real. People are hungry. And you know what happens when people get very hungry? They also get very angry. I always complain that Ghanaians are too laid back. They don't get angry enough. But I'm told that last week, they actually got so angry, they marched all the way to the president's house and so on. So the conversations that we're having are real, they're meaningful, they make a difference to the lives of people. And that is why we must look at, as I said at the beginning, at the broader context of our conversation. The international institutions are particularly important in terms of developing our societies, our economies, and the rest of them. Ghana is so rich in herbal medicine, I only discovered recently. Our herbalists in Ghana, this is heritage medicine. They are so powerful. I personally know at least 2 people who have been cured of their cancers. They can do amazing things, but because we don't control our economy and so on, we're not able to project these and sell them, license them, and take advantage in order to benefit our own people. I know that I've overextended my time. I'm sorry about that, but I will join in the conversation when Jackie and the others have had a chance to do further work on these preliminary observations. Thank you very much.
Thank you, Professor Akuffo. And really, again, highlighting how law continues to still legitimize accumulation by dispossession. It's not just what happened in terms of chattel enslavement. Those institutions, those structures are still there. But we're going to move on, and we're now going to hear from Jacqueline McKenzie. Jacqueline holds degrees in law, human rights, and international relations, and is a solicitor in England and Wales and a barrister in Grenada, with several high-profile and reported cases behind her. Thank you, Jacqueline.
Thank you, Esther. It's kind of strange to hear about qualifications at my age. I didn't spot that on your list there, actually. No one's ever asked me about my qualifications for a very long time. Anyway, well, thank you, and all protocols observed to the rest of you, but I want to escape from the protocols for a minute just to acknowledge Professor Kwame Akuffo, OBE, the Emeritus Professor of International and Comparative Law at the University of West London for a very personal reason. He was my lecturer when I was an undergraduate student. He taught me a subject that is really relevant to reparations. I think it was 1986. And it's equity and trust. Never understood it then, still don't understand it now.
My fault.
And you were the only black professor, and I was the only black student. He used to give me these looks. What's wrong with you? What do you mean? And I thought I'd better understand this. Can't let the side down. So I was so delighted when I saw that you were part of this program, and I am truly indebted to you, because in my first year as an undergraduate, I actually found out I was pregnant and actually gave birth the day of one of the exams and almost chucked it in. And it was Professor Akuffo who made me keep going. And I think if Suella Braverman found that out, she'll be coming for you next. So I owe you loads. And well, of the 2 or 3 minutes I've got left, so we've been looking at the question of the law, and I agree with everything that's been said before. It is just really fraught and difficult. But there are a series of propositions as to how we may go about this. And our starting place, and this, this isn't novel to me, lots of people have written and said this, is that the enslavement of Africans was a crime against humanity. And people who are writing on this use as their remit for it, or their justification for this, the sorry, I can't speak, I just need to have a sip of water, I'm sorry about that. The charter as defined in the Nuremberg Tribunal, which actually defined crimes against humanity as murder, extermination, enslavement, deportation, and other inhumane acts, whether or not in violation of the domestic law at the time, which is what's really quite important, and that's absolutely the case that happened, or the experiences of African people. But we also have other sources that we can look at. So the 1948 UN Convention on the prevention and punishment of the crime of genocide, and deliberately inflicting on a racial or ethnic group conditions calculated to bring about their destruction, informs us in this. And even though the conventions of the UN aren't binding, they are certainly influential and important. So we believe that there is evidence in international law that enables us to show that the transportation and the brutalization of Africans constitute a crime against humanity within the discourse or the scholarship that exists around international treaties, and particularly the work done in the UN and work done since sorry, I've just lost my thought there for a minute. Work done by the organization, what's the name of that organization at the UN? With about 20 words in it. No, not that. There was I'll tell you that in a minute. And of course, since Durban. So that's our sort of starting point. But we have to look at when you bring a case, you look at what the defendants are. You know, you always put yourself in the shoes of the, another lawyer in the room nodding at me, but you look to see, well, how's the defendant going to defend this? And what we've heard so far is that, well, you know, slavery, certainly chattel slavery, was lawful. And lawyers who are working with us and looking at this have said, well, where is the law? Because for something to be lawful, it needs to be stated as law, and there is no example of this anywhere. They refer to the concept of intemporality, which is the way of defining whether something is lawful or not at the time. And according to the principle of intemporality, a legal question has to be assessed on the basis of the laws. So there was no law, so it therefore couldn't be lawful. We aren't completely out of the woods with that, because as we know, and if you were in the room earlier, when I said that the various pronouncements that we've had on this seem to exclude Africans from it, in that Africans weren't deemed to be humans. So it looks as though that lots of these doctrines and declarations were actually referring to other types of slavery, almost akin to modern slavery that we have now, and not to chattelization. However, we have the George II statute, which actually explicitly prohibits the transportation of people, and that's exactly what happened. The movement of Africans, that may not necessarily assist us with a more global concept as to what reparations might mean within the jurisprudence, but it certainly does take us to the descendants whose ancestors were transported. And we do have in this case that, I mean, every article you read about this case seems to say something different, so us lawyers are always grappling to understand what it means. But Somerset and Stewart, which is a case from 1772, and if you've done some reading on this, you probably just know it as a Somerset case, where we would want to rely on the judgment of Lord Mansfield, who was sitting in the then King's Bench. And he was looking at the rights of an enslaved person on English soil not to be forcibly removed from a country and sent to Jamaica for sale. And he decided that the statute or the state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, which preserves its force long after the reasons, occasions, and time itself from whence it was created is erased from memory. It is so odious, and this is his words, that nothing can be suffered to support it but positive law, which is where we get this concept of, or where we get to rely on, intemporality. And he goes on to say, whatever inconveniences, therefore, may follow from the decision, and when I spoke earlier on about the floodgates, because that's what the courts are going to be concerned about. Ooh, sorry, I was only just getting going. I mean, that's what the courts are going to be concerned about, is the floodgates argument, the cost of this. We've seen some of the work that's been done on trying to put figures on what reparations might look like, and I know that that's equally controversial, but we have some scholarship from the Brattle Group and others. But his view that no matter how difficult this decision is, I cannot say this case is allowed or approved by the law of England, and therefore, in his words, the black must be discharged. That's how he referred to our ancestor, as the black. So slavery has never been authorised by statute with England and Wales. And Lord Mansfield further found that it also was unsupported with England by the common law. And we've just recently had legal discussions with counsel, including Ed Fitzgerald KC, who's doing some work on this for one of the Caribbean islands, who made this point. That case was closely followed through the empire, and there were several cases that preceded it. But scholars are still unsure of how we use it today, but except for to say that it is absolutely clear that we didn't have law then. So the idea, I mean, unless you're accepting, and it would be absurd to accept that Africans weren't protected by that law, then they are covered. And because my time has run out, I'm just going to skip the other two cases and just say that the British will say that the slave codes is what enable them to practice this. And Lord Mansfield actually does go on to say that the slave codes themselves can't or must have been unlawful. Nobody got to test it, because the only people who would have tested it would have been the people who were enslaved. And you know how difficult it is now for black people to get lawyers or to be represented fairly. Can you imagine back then somebody popping up and saying, I want to bring my case? Although there are cases, I mean, of course, the case of Somerset was somebody bringing a case. But so we have all of this. We have this possible idea that the law that seems to, or that the British, contemporary British historians and politicians, because you see them from time to time, articulating the idea, my time is up, articulating the idea that the enslavement, of Africans was lawful, and we have to continue to counter it. And one of the ways we're going to have to counter it is by setting up a commission that goes right back into the legislation. I mentioned earlier on the cases that we've seen go wrong in France and the US, but there is an enormous amount that we are unearthing, and there is an idea to bring a petition to the Judicial Committee of the Privy Council. It is a CARICOM, unfortunately, Esther, petition, but how that works is that what we want, or what the people bringing that petition want, is for the king, because you petition the king effectively. So King Charles will be petitioned to make a declaration and to refer the matter to the Privy Council, to the JC of the Privy Council. And he can't possibly refuse to do that, because if he does refuse to do it, then he's, can you imagine? He's effectively condoning the enslavement of Africans. But all that does, because if something is referred to the Judicial Committee of the Privy Council, it gives us a declaration in the same way the work that we're looking at doing with the Inter-American Court of Human Rights and the Committee for the Elimination of Racial Discrimination, the UN Committee, and also the Inter-African Court of Human Rights. All of that work will only provide us with declarations, but those, because none of those decisions are binding on any state, but those declarations will be absolutely powerful if we are to bring cases into courts. And so the work continues to explore, but we think there's possibilities.
Okay, thank you. Thank you, Jacqueline, for that, and making sure you had the time to end appropriately. So we're now going to move on. We're now going to move on to hear from our next speaker on the panel. We have two other contributions that are virtual. That's why I'm trying to hurry us on. That's okay. We're now going to move to hear Priscellia Robinson, who is a founding member of Queen's Court Chambers and head of chambers. In 2019, the United Nations Office of the High Commissioner for Human Rights awarded Priscellia Robinson as a UN Fellow, alongside receiving UN training in international human rights law. Thank you.
Greetings to everyone. Greetings. I want to say that I am indebted to all these people who are actually on the panel today, because they have all actually mentored me at some stage in my life and career as a barrister and also as an academic. I'm particularly actually grateful to Professor Kwame Akuffo, who is actually my supervisor currently at the University of West London, and I want to thank him for all the hard work that he's done. I know he's gone through quite a lot, but in training me and others in the sphere of law. So I'd really like us to give him a round of applause, please. So I've come back quite empowered. I've just probably about 4 or 5 days ago stepped off the plane from Gambia and Senegal, looking at my ancestry, and I visited the island, Gori Island. I don't know if any of you have heard of it. Which is an island of which my ancestors potentially were taken from. And the reason I mention this is because when I got to Gori Island and visited one of the, as they would call it, slave houses, which is rude in itself, there were 4 rooms for women. The first room for women was the room where all of the women potentially were taken. There was another room for women who were virgins, and then once they were, their virginities was taken away from them, they were forced into the first room that I spoke about. The third room was a cupboard, I'd call it that, where women were imprisoned for rebelling and resisting against the human rights violations that we're facing. And the last room, in fact, once you see the door of return, there was a corridor on both sides, one for men and one for women who had been chained together. And the reason I make mention of this is because I thought about their journeys and this collective journey and all that we're doing today. I'm also the president of Birthmark of Africa as well, which helped to organize this event. And the fact that we equally are together on this journey, regardless of whether we do law or not, we are here together. And I just want you to remember that journey that our ancestors went through, and the fact that they were chained together, and we must continue this journey as one together. I was very fortunate to work with His Excellency Judge Patrick Robinson alongside Professor Vereen Shepherd and Professor Robert Beckford, who is also here today, and another lawyer, Natalie Reid, on the quantification for reparation for transatlantic slavery, which was the Brattle Group report, which many of you have heard of, to say that Britain owes around £18 trillion. Now, it's very important when we look at this report not to take it just in itself. As lawyers, we often do have to quantify. We have to start with the quantification of what is owed. And the reason why that report is very important is because, as we can see, and we heard from Sister Esther, who I've worked with on many occasions, that this reparatory justice work is being hijacked. We are being told what we should receive. And it's really important that we do look at this report. It's the first of its kind. I know that Professor Beckford had done a series called The Empire Paid Back, but we took the quantification of African chattel slavery into another realm. And one of the things that I do want to mention surrounding this in terms of how we got to the damages that are owed, which is technically compensation, was looking at the reparations for the period of African chattel slavery, but vis that of reparations after what I would still say we're in the phase of colonialism. And one of the things we couldn't quantify, which is very interesting, is the psychological trauma. That was very hard for the Brattle Group and us as 5 on the committee to actually quantify. And I want us to really, really bear that in mind, because the report is extensive in itself, but there was so much more that we wished to do with the report, but we just couldn't do it because there was no case law that could assist us with quantification. So whenever we talk about the law and we look at it from a perspective of also history and also what's happening now, we do also need to think about the fact that things will come up, and to give ourselves and allow us to have space in order to quantify at a later date. That we shouldn't accept anything, whether it's in law or just through social justice, that this is what we can have on the table, because we also need to look at quantifications surrounding crypto. Where are we going now if we just given a wad of cash? So there's so much to think about. But skipping from that report, there is something that I want to touch on, which is around the legalization of African chattel slavery, and Jackie is right, African chattel slavery was never legal in the UK. And I've taken this a little bit further in terms of this research, past the Somerset case, going before the Somerset case. In fact, in 1102, the Council of London adopted a canons as a decree against slavery. This is before African chattel slavery actually existed in its form, in which they said, let no one dare hereafter to engage in the infamous business and prevalence in England of selling men like animals. We can even go a bit further as to 1215 of the Magna Carta of Clause 39, which it says, no free man shall be seized or imprisoned or stripped of his right or possessions, or outlawed or exiled, or deprived of his standing in any other way except the lawful judgment of his equals and by the law of the land. African chattel slavery was never lawful. And what we find with cases such as Somerset and those before and after was this dilly-dallying of judges having a bit of a fun time as to classifying our people. Is it legal, is it not? And so I really want us to hold on to that. But also something that was mentioned in regards to the Somerset case where Lord Mansfield talked about positive law. Positive law in itself is the law that we as, let's say, men and women make. But there was a law before positive law, before men started to make law, which was the law of God. And this is not just from a biblical sense, but actually from a legal sense. Because the law of God, the law of our Creator, always deemed that people of African descent were human beings. And therefore, to even try to classify this in the sense of positive law is wrong in itself from a legal standpoint. We do need to think about that. What we also found in terms of this is how do we advance this? We can advance this from a international perspective, yes. But there is also avenues for us to advance this from a legal aspect here, domestic law. Unjust enrichment, for instance. So if we look at the law of equity, the law of trust, we have organizations such as Lloyd's of London, who enslaved African people, also insured African people, and they do hold trusts currently to this day. And unjust enrichment is when you are enriched from an illegal act. So if there are currently trusts that are out there which come from unjust enrichment, then the duty of those trustees are to ensure that those who may be beneficiaries are contacted. Now, I do wish to go into a bit more detail, and I must say that I did a presentation at the University of Cambridge on this and stunned a few of them as to how it would take what they would classify as private actors to court. And I do have a paper which I'm happy to share with everyone on this, but this is very important that when we're talking about African chattel slavery, we, as people, whether we're lawyers or lay persons, always remember that we are not to be told what is owed to us. And when I walked on Gorey Island and I felt the spirit of my ancestors, I'm telling you for a fact, even being a part of this battle group report and saying 18 trillion pounds based on the quantifications, for me, I was angry to say that is not even enough. So I just want us to always think that regardless of what we're being told through the law or through social justice, that we as the living remnants, the descendants of those who were enslaved, must always hold on to the fact that this is not something to be played with. And the future of our future generation, we are holding the key right now, because the decisions we are making surrounding this situation, any compromisation that we wish to do, will have a detrimental impact upon them. Thank you.
Thank you to Priscellia Robinson for that contribution. We have one more. Unfortunately, Professor Isabel Feichtner has had to leave, but our final contribution, whoever's keying it up, is from Dr. Nora Wittmann, who is the author of a book that some of us know very well and really appreciate, Slavery, Reparations, Time is Now, Exposing Lies, Claiming Justice for Global Survival. an international legal assessment which lays out the assessment of the global illegality of chattel slavery. So Nora Wittmann is an international lawyer, writer, and fashion designer. And we should be listening to Nora.
Good day to everyone. So I'm Nora Wittmann, and I'm going to speak on the question of the legal status of transatlantic slavery and enslavement at the time it was perpetrated. It's central to the legal reparations struggle and debate in the sense that the dominant opinion, accepted international law opinion, up to my research, has always denied reparations on the principal argument that facts in international law have to be judged by the law, by the rules in place, that facts happened. So if it is argued that transatlantic slavery would have been so-called legal, which is what the European enslaver states and entities and reparation negationists have always said, then it would follow that legally speaking in international law reparations would not be due because it was not illegal at that time. So that is what they always relied on. But that argument always did not make sense to me when I was confronted with the facts of what transatlantic slavery and chattel enslavement really was. It did not make sense to me that that could have been legal if you look at law and at international law and what purpose it serves, and it does not make sense that something like that, when you really know what transatlantic enslavement and chattel slavery was, that would have been legal. So I embarked on a research journey, a PhD journey. I got my PhD with that research, but the reason why I started the research was not to get a PhD, but to show waterproof once and for all that this argument by the ex-enslavers and reparation detractors just doesn't hold, to show that once and for all that does not hold. So I'm sorry that I cannot be at the conference when it is happening. I have to record a video because I'm just setting up I just relocating with my children to Jamaica, and tomorrow when the conference will be happening in London, he will be there and they will be around, so that is not going to be possible for me, unfortunately, but many thanks to the organizers for putting up this conference and for inviting me. So I will do my contribution with a little video. So as I have said, that is one of the most fundamental, important rules in international law, the principle of non-retroactivity, that facts always have to be judged by the law that is in place, in force at the time that something happens. If conduct, a behavior, an act is not illegal at the time it happened, there's no violation of international law. If there's no violation of international law, legally speaking, there's no claim to reparations. So that is what they have always said, that it would have been legal because they made all these laws, these code noirs, the French say, and that it was legal, but it does not make sense. And we also have to start with a non-Eurocentric perspective on that. That is not even putting the main focus on European laws and only on European laws, but that look into real international law, because before this crime happened, that even up to today is the foundation of this system of European world dominance on many levels that we got to here. That is only because it's built on the foundation and the same structures that were established violently since transatlantic enslavement. So we cannot just look at European laws, at so-called international European law, but we have to start that quest to uncover the real international law and regulations when it comes to sovereign labor and slavery, with the African perspective also. On that, I was inspired, of course, also by African reparationist scholars like Kofi Malumi-Klu. And yeah, so I tried to, building on that, find as many sources, documents, historical researches on how the African regulations on servile and unfree labor were. And before we even go into that, one thing that some Europeans and reparation detractors are also arguing is that at that time, that African states, or that African states would not have been existed as such, that African political entities would not have been on a level with Europeans, so would not have been able to even contribute to what is considered international law. But that is an illusion also. We know that there were many African political entities, states that were at least on par at that time with European states. They had organized statehood. But even beyond that, I think we also have to look into the fact that that, to an extent, still judges the whole thing through European spectacles. So even other African societies that might not conform to European international law concepts of sovereignty and territory and population still respected human rights and still were in contact with each other and had treaties and all of that. So we definitely have to look into African laws also. And when we do that, we will find that in no African societies, even those that were exchanging captives, war prisoners, criminals, instead of putting them in jails, trading a certain amount, exchanging between sovereigns, that was normal to an extent all over the world. But even those so-called slaves cannot compare in their treatment and the conditions that they were lived in to what Africans in transatlantic slavery were subjected to. There was nothing like whipping people to death. There was nothing like putting them in whole body or even facial gibbets. There was nothing like all of the atrocities that we read of. There was nothing like that in African societies. And we also have to know that when the Europeans, the Portuguese, started coming to Africa to first kidnap the first Africans to take them to the islands, that they were met with resistance, so they had to kidnap African people. It's not like African people were just there selling them one another like it's sometimes portrayed. So but then they wanted to get more people, so they started to engage with certain African royals like King Afonso of Congo. And he at first was doing that thing that I spoke about with them, that he was giving them a certain number of captives, war captives or criminals, but then they were taking more people. They were kidnapping people still, and he protested. He sent official letters to representatives of the royal crown, of the Portuguese crown, protesting that this, what is happening, this can't go on, my people are getting stolen away. But they ignored it, and they still kidnapped people, and then in the process they were arming one faction against another. And it's not difficult to find anywhere in the world one or two corruptible individuals, you give them arms, make them do an insurrection, so they do what you want them to do. So that is what was happening, and it was happening with time on a massive, massive scale. Europeans were bringing in the 18th century, were bringing hundreds of millions of guns into Africa for the sole purpose of getting.
Okay, we're going to have to not hear the whole presentation, but thank you, Dr. Nora Wittmann. I've got strict instructions that we have to finish by 4 p.m. because obviously there's another set of workshops, discussion, that we've got to hear. And maybe we've got a minute or two. I'll take the chance of 3. Okay, all right, 3 minutes. We've got 3 minutes. We did want to hear from some of you. Okay. Okay. Yes.
Having listened to the conversations and then listening to what you're saying about law, what springs to mind is the issue of power. How do you all see about power and its relation to law? So isn't the focus on getting power, and then you can sit and talk about law?
Thank you for that question. Brilliant question. The importance of the connection between law and power. We're going to take several contributions. I'm trying to be, I'm going to reckon there's at the back here, up here. Yeah. Okay, no? Yes, go ahead. Okay. Thank you. And one more. Hold on, please. One. So basically was speaking about the situation in Tigray and how the government is implicated in killing the people. And where do we draw the line? Because connecting it to this issue of power and how governments can misuse and are misusing power. One final contribution. Sorry. Okay, go ahead.
Yeah, just very quickly. I wonder if the panel could speak on the precarious nature of stare decisis and accepting compromise settlements. I think those two issues that are going to be very important, especially if the grassroots are not engaged.
Thank you. We've only got time to hear very brief responses to those 3 connected points. Who wants to go first? Go ahead, brother. Can you repeat it very quickly?
I'm asking the panel to comment on the principles of stare decisis. That's where a judgment stands once you bring a case to court and a judgment to make, and if you can't bring it again. The other thing is compromise settlements. And if you accept a settlement that is undervalued, you can't re-litigate.
Okay, thank you. Responses from the panel. Sorry to rush you. Go ahead. Who's starting?
Should we just take one each? Or
Okay,
one,
yeah.
half, a third of one. Well, I suppose on stare decisis, I mean, we see this in Windrush, actually, where cases are decided and we can't go beyond them. So it's problematic, but that's why we need to make sure that whoever's doing our bidding does it properly. Of course, the principle of unjust enrichment does allow us to come back if something is just so wrong in a decision. So there's scope, but we haven't even reached to work out which tribunals, who the claimants are, who the defendants are, what the quantum is, etc. So we're way off any decisions which stare decisis requires. Just one other thing on ICI 3. Is that your name? You call yourself ICI 3, don't you? I've seen you at some other events. Just on power, absolutely. It was a point I was making earlier on about where you see the executive, the judiciary, and the legislature all overlapping, and that's what power is. And so it's going to be difficult, actually, to get justice in courts. Please don't anybody go away and say I'm saying the courts are corrupt and the judiciary is corrupt. I don't want to see that on Twitter. That's not what I'm saying. But we know that there are issues, particularly where there is discretion, and very often there is discretion. So it's difficult. And on Tigray, yeah, a heart goes out. I mean, it's awful. But you know, this whole artificial drawing of borders and lines and so forth goes right back to the very issues we're talking about and the whole idea of colonialism, you know. So it is part of the reparations discussion, and the issue about poor leaders is something we're all going to address when we work out who gets the reparations.
All right, I think Priscellia wanted to go next. Thank you. And then Peter. Thank you.
Yep, very quickly, of course, the ongoing... let Judge Professor go.
Just very quickly on the issue of power. I think it's a very important question that you raise. And remember, at the start of my contribution, I warned about the limits of law and being aware of what law can and cannot do. I'm reminded of the fact that the human rights elements that were put in the United Nations Charter were in fact the result of NGO activity, Eleanor Roosevelt, the campaigning activity of ordinary people who were so determined to make sure that the never again to bring peace to the world meant that you had to put people at the center of peace. It wasn't good enough to simply write a document saying you have these rights, you have those rights. From that point of view, the lesson that is very clear about how you balance power and you enable us to prosecute our interests is to make sure that ordinary people are empowered. You know what happened in Sri Lanka when they had their issues? They marched into the presidential palace and literally lifted the president out of his spirit. It's the only language the politicians I know understand.
Right.
Yeah, you know that.
Absolutely.
So,
all right.
in order to give reparation teeth, ordinary people ought to have the power to be able to force their governments, form movements. So NGOs are what makes civil human rights so potent today. They join in, they do campaigning activities. So it's a very important question, one that we need to work on. Thank you.
Thank you, Professor. Okay, Priscellia, and then Peter, and we have to wrap up. Sorry.
Colonialism is still live and kicking. The ongoing legacy of African chattel slavery is still live and kicking. And I have a questionnaire, 2 questionnaires that I want to quickly say. Esther's a part of one of them, which is the Church of England's commission, the 100 mil, what needs to be done with it. I just want to say, if you want to fill out that questionnaire, come to myself or Esther. But there's also another one, which is the ongoing legacy of African chattel slavery, and particularly how it affects the Windrush generation. Please fill out that questionnaire as well. But if you take anything away from today, please remember something called retroactive liability. Retroactive liability is very important, just to quickly say. It's where, even though something might have been legal before, you can change it in law. Retroactive liability. And they did this in the 90s for those who should have been prosecuted for war crimes in relation to the Second World War. So if we are ever told that African chattel slavery was legal, and we now know that it is a crime against humanity, then we can rely on a retroactive liability.
Thank you. Finally, Peter, 10 seconds, because Belle has come in and...
Yeah, well, I'm a judge, so tough.
we got our Pan-Africanism panel.
So the retired or not. Kimatai Bosek from Kenya has taken on the British government and won on behalf of the Kipsigis and Talai people. The question is, how do you get that money from the UK government, who use a settlement on Mau Mau to say that despite it had absolutely nothing to do with the rights of the Kipsigis and Talai people, you've all got that in Kenya, go away. Real problem. Power. power no longer rests with the Western world. It lies in China, it lies under the sea, and it lies in Africa. So the power dynamics, you have to make alliances outside of the norm and disrupt the status quo in every which way you can. And while we're on that, thanks to people like all the panelists, Professor David Olusoga, I knew there was atrocities committed in the Second World War. What I didn't realize, there were 3,000 Africans, 3,000 who were massacred by the German troops as they invaded France. 3,000. Never mind Maangamizi massacre, never mind First World War. But more recently, the German government has never been held to task for that. They are liable. Right. So, and finally, the final thought is, sue and sue and sue again, because if you do, the arguments your oppressors have to bring against you are so deeply embarrassing that you may lose in court, but you win in the court of a public opinion. Do it.
Absolutely. The courtroom of public opinion. We have to close this session. The next sessions this afternoon in this hall is the session on Pan-Africanism, racial justice and intersectionality with Sarah Fell is on the first floor. The second floor we have community regeneration discussion with Benjamin Leigh, and also on the second floor we have media and social transformation. Pan-Africanism in this hall, racial justice and intersectionality on the first floor, community regeneration and media and social transformation on the second floor. Can we please make our way to wherever we're going?
Can we also give a round of applause to Esther for hosting this
and our panelists for sharing their perspectives. Thank you.
Thank you, Esther.